Well, hello there, and welcome to the Disability Law Show again this week. I'm John Scholes, and joining me again this week, Tamar Agopian from Samfiru, Tumarkin LLP, the most positively reviewed law firm in the country. Reach out to Tamar and her team anytime. Just a phone call away, as they say, 1-855-821-5900. Email is help@disabilityrights.ca. I'll give you more ways to contact Tamar and her team throughout the half hour for sure. 3 frequently asked disability rights questions. That'll be the main topic in just a little bit. A little later on the show, we'll get to some phone calls, emails, and other content as well that you've been sending in over the last week or two. So let's get busy. Tomorrow, we always kick every show off. We get warmed up, as they say, with a recent case of yours or something that's going on your desk. What do you got?
Well, so I recently settled a claim for a client, and we're bound by confidentiality with these settlements. But during the mediation process, John, where we settled the claim, we were talking about our shows, and we were talking about how he's an avid viewer of our television shows, and what he wanted us to share with our viewers is actually our client experience. He's like, you guys don't share too much about how great it is to work with you, and how little we need to do through that process.
I like this guy already.
He's lovely, honestly, John, and I was so thrilled that we had such a successful result on his claim. But I actually thought his comment was somewhat insightful, because we actually don't share a lot of what we do sort of behind the scenes, behind the curtain. And so I think a lot of people see the initial contact. Of course, people know, I hope at this stage, that our consultations are free, but then what happens? And so really, we are there to hold people's hand, sometimes quite literally, throughout the whole process. We try and make it very, very simple right from the start to work with us, to get us retained, and then we do literally everything else. John, the phone calls from the insurance company stop.
Nice.
We get all the medical records. We will deal with the insurance company. We will actually direct sometimes what the doctors need to provide to us in terms of reports or information. We might even suggest to our clients or our patients, our clients rather, as patients, look, have you and your doctor discussed X, Y, and Z? That's the doctor's swim lane. That's for them to do. But because we've done this as long as we have, we understand what the insurance company is looking for. And so it is really one of those best kept secrets, I think, about what does actually happen behind the scenes. And then the process to resolution, sometimes the clients don't need to do anything else. They just retain us. We do everything else. I will reach out to the client and say, okay, this is an opportunity to resolve. This is what it's going to look like. I speak to them. I speak to their family members. I will write them, emails and reports and this sort of thing if they need it. Because the other thing that insurance companies lack a lot of sensitivity around, John, is that a lot of these disabled claimants, when you say something to them over the phone, it doesn't necessarily mean they've understood what you've said to them. They need to sometimes have multiple conversations or have things put in writing so that they can take the time that they need to think about it or understand or talk to a family member or their medical team. We understand all of that. So I thought it was so helpful to have a client comment to me about that aspect of it, to say, look, you took the stress away, Tamar. We did this so much quicker than I thought it would be. The outcome was amazing. You were respectful to me. He had a common law spouse. I obviously spoke with her quite a bit. And you really helped us navigate through that experience so that the outcome was not only positive, but you distinguish yourselves so differently than what it was like dealing with the insurance company and how challenging that was. So I thought it was a great way to start off the show, because I think that we are so focused on addressing people's emails and getting information out there that we don't spend as much time on the things that we do sort of behind the scenes and the sensitivity and the sophistication and the understanding that we bring to dealing with these disability claims and getting them resolved. That's the key. And getting the things and the compensation and the entitlements that our clients are owed right from the start.
One of the first things you mentioned was the phone call stop, and that's from the, the disability insurer, the adjuster, whoever that is. I don't think you can overstress how big a piece of the puzzle it is for someone who's especially really suffering and just does not need to get harassed on a weekly, if not more often, basis from the insurance company. All of a sudden, it's radio silence once you guys get involved, right? How good is that?
It's radio silence, and it's a level of trust that we've got this.
Right.
I've got this. I assure you, myself, every one of our team members, James and Savannah, and everyone who work in this disability realm, there's a reason we do this. Not only are we passionate about it, but we are really sensitive that there's a human being there at the end of it. And I can't stress that enough, not only to the client, but to the insurance company. Humanizing it to the insurance company sometimes can go a really, really long way. You know, it brings to mind some of the strategies we use. And one of the things that I found really, really effective, John, is sometimes getting family members to write down what they've observed, what they've seen, can be really effective. And so at times I will ask, you know, the common law spouse, this child, the daughter, the husband, whoever it is, to write just a few words about what they've observed. And I use that as part of the advocacy, the thing that we do to persuade the insurance company that, look, this is the way it's got to be. And while we do that, in those conversations, it's no direct contact between the insurance company and my client or anyone who's helping them. And that can be huge because they get distracted, they get stressed. It adds to whatever health profile that they have to deal with the insurance company. And these adjusters don't really care. They recognize that they have a month-to-month benefit. They release that benefit only if they've checked off the boxes in their file about what it is that they need for information. And when they do that, then they will release that payment. But if they don't have that, guess what? More phone calls, more emails, more letters, more, well, get me this, get me that, get me that. There's some claimants who tell me my job now is to deal with the insurance company. It's even more stressful than my regular job that I was doing, let alone my health issues. So it can be incredibly effective to allow us to do this work for people, to do it right, and to allow them to focus on their health and their recovery and distance themselves from what's happening with the insurance companies.
And I think it's worth mentioning, I know you've talked about this in the past, that, in your case, in Savant, who's, 50% of the nameplate of the firm, you guys, you're on the dark side. You know what it's like to deal with the insurance companies, and so you've got the inside track, right?
Absolutely. I was just actually speaking to someone about that this week. Obviously we do lots of free consultations, speak to people all the time about their disability claims. And that comes up, every so often. I sort of say, look, I've worked for one of these insurance companies for a number of years. I know how they're coming at this. I know what they're going to look at, what they're picking apart, and frankly, where their weaknesses are. And I think that is really important when you're thinking about who should I select as my disability lawyer? Who do I want on, behind me? You want people who understand, who are empathetic, who understand the ins and outs of the insurance companies and can leverage that ultimately to get a resolution.
A free and anonymous tool for you to use anytime, Pocket Disability Lawyer. PocketDisabilityLawyer.ca is how you reach that. Tamar, I know you're a big fan of this. Break it down. What do you like about it?
I really enjoy and love this tool because it is really an add-on from our Pocket Employment Lawyer. And what's great about both is that you can find out about your rights and entitlements, both from employment rights if you're interested, and also your disability rights. And it's completely anonymous. It is very user-friendly, John. No legal speak, no terms that are, you're not going to understand, because I know insurance companies love to throw terms at people. We've tried to simplify it so that there are drop-down menus, and you can sort of click and select, and it will navigate you to provide little blurbs of responses. Now, the other really important aspect of this is that it's anonymous, and there is no obligation to speak to any one of us if you do not want to. And I think that's important because I don't want people to feel like, well, I want to know about my rights, but does that mean I've got to spend a half hour talking to a lawyer? No. If you don't want to, there's an option actually to say no to contact you, completely anonymous. You take out from the browser and you're done. You get the information that you need, and hopefully that's helpful for you as you navigate your disability claim.
Catch our radio shows. Simply go to disabilityrights.ca to find a station near you, including the GTA here. We're all over that. Call into the show. You're always encouraged to do so, and possibly one of your phone calls will appear on this show, and we'll talk about it if it's interesting and helpful, which we're going to do right now. First phone call for the show tomorrow is coming up right now.
What happens if you're approved for short-term disability benefits through work, but the insurance company then denies your claim for long-term disability? Should you appeal the denial? Is there a limit to how many times you can appeal?
The insurance company will say no. Appeal 1,000,000 times if you want. We'd love that.
And look, and this idea of, is third time the charm? Yeah. It absolutely is not third time the charm, right? And so, but it's set up that way, John. It is set up in a way where people believe that this is the right process. In fact, people who are unionized have told me their unions are advising them to continue to appeal.
Appeal.
It's It seems so official.
Yeah, right.
But it is not in the policy. It's like a cowboy land, wild, wild west, that kind of thing, because it's not regulated. It's not
No
required.
third party.
There's no third party. Yeah. There's no oversight. There's no requirement to assign a new adjuster or someone new at the company to review it. Even so, it could be someone across the hallway or beside the cubicle or a phone call away. It doesn't necessarily mean that it's being looked at with those so-called fresh set of eyes. But I can assure you that when we start that legal claim, it's going to be a fresh set of eyes. We're going to be dealing with the insurance company's lawyer. They're going to be dealing with us, and we are going to be leveraging issues that you wouldn't necessarily know as a claimant and that your adjuster, frankly, wouldn't see as a risk, like the reputation of the insurance company, their financial risks. What does it look like if it's going to be a payment of these disability benefits until you turn 65 years old? These are really effective ways that we champion our rights for our clients. And we don't get that opportunity if people don't give us that opportunity, or if people feel that their only option is to appeal. And so I really don't like that, John. And I especially don't like it when our caller tells us, but I was approved for short-term, and I'm being resisted for my long-term claim. Why is that happening? That transition from short-term to long-term, it shouldn't happen. The definition to qualify for disability benefits for short-term and that first phase of long-term disability is the same. So if you've been approved for short-term, it should be fairly routine, if your doctors are still supporting that you can't work, that you then transition to long-term. But sometimes long-term is insured and paid for by the insurance company, whereas short-term, maybe the insurance company is only reviewing it, but if they approve it, your employer pays that benefit. So now it's affecting the insurance company's bottom line, and they have a financial incentive to try and weed out these kinds of disability claims and hope that people just simply don't assert their rights. And this is why the appeal process is such a sham, because it leads people to believe that there's going to be a different outcome. It's human nature to think, okay, but if I just provide this one other thing, it must mean that it's going to persuade this adjuster that I'm truly disabled. And oftentimes it's not the case, unfortunately. And what it does is that it wears down the claimant. Sometimes it even wears down the doctor to have to keep providing more information. And then you're at a point where everyone's throwing up their hands, and the only answer is what? This poor claimant forcing themselves back to work when they're not supposed to, or perhaps more importantly, leaving money on the table. Benefits that they are owed that they are not getting because they've been frustrated through this appeal process. So I really don't like it for a whole host of reasons, especially if it's going to create a wedge between a patient and their doctor, the person who is trying to advise and treat them, and to not allow people to exercise their rights early on to get the help that they need, to get the compensation that they need.
We'll take a short break, and on the other side, 3 frequently asked disability rights questions, but you got to wait for it for a moment, so we'll get to that right in a quick second as we continue here with the Disability Law Show. Stand by.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
And welcome back. Thanks for sticking around. The Disability Law Show again this week. I'm John Scholes. That's Tamar Agopian from the firm. You'll want to reach out to Tamar And her team, very capable, always ready for that phone call to chat. Won't cost you anything just to pick up a phone. 1-855-821-5900. help@disabilityrights.ca for the email. Okay, main topic. Let's get into this, Tamar. 3 frequently asked disability rights questions. You love these because they're pretty rapid fire and they're pretty concise as well. Number 1, what is the difference, Tamar, between the own occupation and any occupation definitions in a policy? I can see why that would be confusing.
It is confusing, and this legal speak, they put these words in these policies, and then, John, they land them in these letters that they send to these claimants, and they're looking at this thinking, well, hang on, I was approved for this, and I'm not approved for that. What does this all mean? Before I answer this one, though I got to tell people, there is an excellent memo on one of our websites called ltdfaq.ca that actually deals with all of these terms. So if people are confused and they're not sure, please do access ltdfaq.ca. So, but to answer this question, any occupation, own occupation. In the initial phase of your disability claim, the insurance company is going to be looking at whether or not your health is preventing you from doing your own job, own occupation. And actually, job is a little different than occupation, but for this discussion, let's just stick to job to keep things really simple. The test in the vast majority of disability policies for that first phase to get short-term or long-term is if your health, illness, symptoms are preventing you from doing the work that you were doing at the time that you became disabled and your doctor said to you it's time for you to stop working. But after that initial phase under these policies, and usually it's about 2 years or 24 months of benefits, the test changes. Insurance companies have made sure the test changes so that they can then make it harder for people to qualify for disability benefits. And that test change you see in the long-term disability policies. And it goes from the insurance company looking at what's the work that you were doing, what's your health, how does that line up with your ability to work, to now looking at what is your education, training, and experience? What is it that you've been doing even before your prior job? And could you, even with where you're at with your health, go out and do some other job, some other occupation that would pay you roughly what you're getting for your LTD benefit? Let me emphasize that part again. It's called the commensurate wage. It's no longer that the insurance company is going to be looking at, can you go back to your prior job and earn 100% of what you're making? Now, not only are they looking at any job, they're also looking at any job that would roughly pay you about 2/3 of what you were making before. So the test is tougher, the threshold for earnings is lower, John, and that then sets up nicely, of course, for the insurance company to say, there's something else you can do, and you know what? We're going to deny your benefits. That's usually where we see most people come to us for advice, and of course, we challenge these things all the time on behalf of claimants.
Frequently asked question number 2 is this, Tamar. What's the difference between the timeline to appeal and the limitation period?
Ooh, this one's a good one. So let's start with limitation period, because in my mind, that one is really the one that's most significant. We practice law across the country, right? Primarily in British Columbia, Alberta, and Ontario. But this part is really the same anywhere, which is you've only got a certain period of time to start a legal claim against the insurance company for benefits. And that period of time is 2 years. I know it could seem like a lot, but that clock starts to run the moment the insurance company says to you, you're not entitled to benefits anymore. And if you and your doctors are in the position where you're like, wait a minute, but the patient's still unwell, I still cannot work, well then you know that you've got a claim and you've got that 2-year window from the first point they said no to you to start that legal claim. And this goes back to that appeal process we talked about, John, earlier in the show, because that's where that period of time comes in as people try and decide what to do. And they're lulled, they're coaxed into this feeling of, well, I'm just going to keep appealing. The insurance company keeps telling me I can submit more information and they're going to look at it again and, hopefully they give me a fair shake and change their mind. But what ends up happening is that it's not clear what those deadlines are. It's not in your policy anywhere. They sort of said, did you say to you, well, you've got to provide information within a month or within 3 weeks or whatever it is. But they, as the insurance company, don't commit to responding back to you in that same period of time.
Nice.
So they can take a month, a week, 2 weeks, 3 months. Sometimes I have seen up to a year where people are dealing with an appeal. And what is happening behind the scenes? You're running down the clock for the limitation period, the one that really is hard and fast, which is hiring a lawyer and starting that legal claim. So I really think, I pause here quite significantly because I think it's so important for people to contact a lawyer when they get declined benefits, because you want to understand what your rights are, you want to understand what those timelines are, and you want some clarity around this whole appeal thing. You're wondering, well, of course I'm going to hear from the insurance company in a month, and if you don't, does that mean you can't start a legal claim? No, of course you can start a legal claim if you've been denied benefits. And that is the key difference between the limitation period and the sort of deadlines around the appeal process.
And it could be appeal to appeals very quickly.
That's right.
Here we go, and here we go, and here we go. You're
That's
answering
right.
the wheel, right?
And when you look at those denial letters sometimes, John, it tells you about the appeal, but sometimes it doesn't even tell you about the limitation period, even though insurance companies are required to tell claimants.
Wow.
So, you've got to go to the back of the letter. Most people aren't going to look all the way to the back. And even then, I have seen letters where they don't even tell people, and by the way, you've got 2 years from the date of this letter to start a legal claim.
Not nice. Frequently asked question number 3 for the show about disability rights is this: what types of deductions can an insurance company take away from your benefits amount?
Yeah, so this is the one that bugs me quite a bit because, again, insurance companies will tell you, this is what we're going to pay you. This is how your benefit is calculated. Usually it's about 2/3 of what you're making. But if you come into other sources of income that are related to your disability, we get to deduct that. So the big one that we talk about a lot on our shows is CPP disability. It's a government-sponsored disability plan. It's meant for individuals who have a severe and prolonged disability, and it could pay you on average about $1,000 to about $1,500 a month. And that's significant because if your insurance company is paying you $3,000 a month, and now you can get this government-sponsored benefit for $1,000, guess what? It means they pay you less. They're going to pay you less what you're getting from the government. And so some insurers will really be active about finding out, are you getting these other sources of income? Are you even applying for these kinds of benefits? And so it's important for people to know what is deductible. So CPP disability is one. The other one that comes up quite a bit is workers' compensation or work-safe benefits. So if your disability started or happened as a result of a workplace injury, and you are entitled to income benefits as a result of that injury from WorkSafe or workers' compensation, then most disability policies will also say that the insurance company gets to deduct the income amount. Not the rehabilitation and other things that you might get from WorkSafe, but the income amount then is a deduction against what you're getting for LTD. The last one I want to talk about, and this one is really one that's significant with the work that we do, both with disability and employment.
I know where you're going.
You know where I'm going with this. Severance.
Yep.
Severance. So there have been times, more than I care to admit, where people have actually been terminated either when they start their disability leave, while they're on a disability leave, just before their disability leave. And we can have a whole other show, and we do, about how that sort of plays out and your rights around that. But just to the point of deductions and deductibility, most disability policies will also say that if you get a severance or some kind of income payment from your employer while you're getting your disability benefit, they also get to deduct that amount against what they're paying you for LTD. And that can be quite a significant amount, because you can imagine, even if you get, I don't know, John, $40,000, let's say, as a severance, but your disability benefit is, $2,000, $3,000 a month, that could be a long time before your LTD benefit gets paid, as the disability insurer is taking credit for that $40,000. So I think it's really, really important for people to understand what's in your policy, what does it say about those deductions, so that you know this is how it works. What do I need to let my insurance company know about? If I have a lottery win, do I have to tell them? Absolutely not. They are not entitled to get that. It's a windfall. It's not related to your disability. But some of the other components of things that we've talked about on our show are important to know, and you do at times have a positive obligation as a claimant to let your insurance company know that you're receiving these benefits, because it is fair game for them to receive a credit. But if you have any questions, please don't hesitate to contact myself or anyone on our team, and we can look at the policy. John, it takes us 5 minutes, if not less, and we'll let you know if it's a proper deduction.
And with that, we'll take a short break. Lots more on the way. We'll go to our website, mydisabilityquestions.com, for our next question. So that is coming up. Stick around. More of the Disability Law Show is just ahead.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
Welcome back to the Disability Law Show. Thank you so much for hanging around with us. John Scholes and Tamar Agopian. Reach out to Tamar anytime. That phone number, again, 1-855-821-5900. Help at disabilityrights.ca. But as I mentioned, another website, free and anonymous, mydisabilityquestions.com. Try it out, use it if you have any questions. It may appear on this show. Like Naomi's question, Tamar, goes like this, is after a breast cancer diagnosis, I was unable to continue working. I've been on LTD and CPP disability benefits for over a year now, but I just got a letter from my insurer saying they're cutting me off. They stated that my doctor has not provided enough medical evidence. This can't be true, as my doctor has provided every piece of relevant medical information that he has. What does Naomi do?
This is really frustrating to me, John, because if the insurance company has everything that they need, if they have all of the medical evidence, they know Naomi is CPP approved, which tells me she's got a severe and prolonged disability as per the government. So what is it that the insurance company is looking for? And so I scratch my head in situations like this because I'm just as confused as Naomi as to what is the disconnect. So all I can really advise Naomi is the details are important here. So what she describes to us is that she sounds like she's actually recovered from breast cancer, which is excellent, but she clearly has some lingering health issues. And these lingering health issues, they're not insignificant. I've had lots of clients who've had neuropathy, which is, numbness and pain in the hands and feet. You can have mental health symptoms that stem from cancer diagnoses and fear of recurrence and a whole host of things that can be in a profile of an individual like Naomi. And so I wonder how much of this has been relayed to the insurance company by her doctor. The details here are very important. And so I really would encourage Naomi to have a conversation with her doctor, really understand what has been provided to the insurance company by way of medical evidence. Is it just the raw clinical notes and records? In which case, maybe a report is what is needed here from the doctor explaining, these are the 3, 4, 5 symptoms that she's still struggling with. These are the symptoms that we're still trying to grapple and get treatment for, and I don't see these things getting any better, because that is really the definition of severe and prolonged, John. But really having that underlined to the insurance company can sometimes be extremely effective in situations like Naomi's. And I gotta wonder how much of that is playing into the doctor's advice to keep her off work. So if there is truly a fear of recurrence, for example, can a report from the oncologist around that really help in a profile like hers? Maybe. But I have to get really into the weeds with the medical and start there as a strategy for Naomi to put off the insurance company's inevitable decline. But they've made their decision, John.
Yeah.
So the fact that they've made their decision really compels me to say to Naomi, you know what, let us help you. I will get that medical information. I'm going to get the full file from the insurance company. Let's see what it is that they've got potentially concerns with. Let's see what the denial letter says, and I will facilitate doing that by way of a legal claim, because the last thing that she needs is more stress, more anxiety around the insurance company denying her claim improperly and then not having the energy or the means to fight. That is what we're here for to do.
Naomi, thank you so much for sending that along. Again, mydisabilityquestions.com, available to you anytime as well, free and anonymous. Ask your questions, and Tamar and her team will get to them. Beyond that, always make that phone call as we wrap for another show. 1-855-821-5900. Help at disabilityrights.ca, or simply disabilityrights.ca as well. We'll catch you next time on the Disability Law Show.